Our next speaker is Nele Schuldt, who is a PhD candidate working on the topic of the presentation today for her PhD, funded by the FWO and affiliated to the DISSECT research project. So Nele, over to you. You have 20 minutes.
Yeah, thanks a lot, Marie. And I'm struggling a bit with my internet connection today, but I hope it'll bear with me for this time. So I'll jump right in. Worldwide, over 1,500 climate-related lawsuits have been brought before both domestic and regional courts. The success rate, however, at the moment is rather minimal. Whereas other researchers are currently approaching evidence in climate litigation from angles such as attribution science and how to utilize robust scientific evidence to have greater success, my research really focuses on the question of whether an evidentiary regime indeed exists and how it can be clarified before the regional and the Inter-American human rights courts. In this presentation, I seek to share some really rather preliminary thoughts and ideas on some of the cases that I've been reading concerning the European Court of Human Rights. To start off, with currently 3 pending climate change cases before the European Court of Human Rights, I've made it my aim to really understand the court's environmental case law and how it has developed over the past 30 years. I will firstly briefly explain these issues raised in the respective cases before turning back the clock a little bit and discussing 3 selected cases concerning environmental degradation. The 3 pending cases concern alleged human rights violations as a result of climate-related extreme heat waves, forest fires, powerful storms, droughts, and climate anxiety, specifically in the Portuguese case. The Swiss case concerns elderly women's life-threatening health issues as a result of climate-related heat waves. And the most recent one, the Norwegian Arctic oil case, concerns Norway's licensing of further oil and gas exploration in the Arctic, which contributes to excessive greenhouse gas emissions and threatens the young applicants. These cases have similarities. All of them allege a violation of Articles 2, right to life, and 8, right to respect for private and family life, and the 6 young people in the Portuguese youth case, as well as the 6 young Norwegians and 2 organizations claiming for the Arctic oil case, additionally allege a violation of Article 14 in conjunction with Articles 2 or 8, respectively. The argument here is that global warming is affecting their generation in particular, and that in view of their age, the interference with their rights was more pronounced than with the right of previous generations, especially given the deterioration of the climate. When communicating the case in the Portuguese youth case, the court additionally requested statements on Article 3, which is quite remarkable, right to freedom from torture and degrading or inhuman treatment, as well as Article 1, Protocol 1, the right to property. In the Swiss case, the Swiss Federal Supreme Courts rejected the elderly women's case on allegedly arbitrary grounds, which might constitute a violation of the right to fair trial under Article 6. As well, the Swiss authorities and courts did not deal with the content of their claims, so the Swiss elderly women also claim a violation under Article 13. Now, in light of these 3 pending cases, let us look back at how the court has developed a more, I would call it, environmentally aware approach. The first case I would like to focus on is the 1994 case of Locus, Austria against Spain. This concerned the inactivity and passivity of the Spanish authorities to the applicant's family's exposure to noise, smells, and pollution caused by a waste treatment plant, which was sited a mere 12 meters away from the applicant's home. In this case, the court found a violation of Article 8. Some of the principles I would like to mention to really kick us off is that the court here acknowledges that, quote, severe environmental pollution may affect the individual's well-being and prevent them from enjoying their homes in such a way as to affect their private and family life adversely, without, however, seriously endangering their health. I find it interesting here that the court indeed determines that an individual's health may not need to be seriously endangered for an interference to possibly take place. The court then goes on to state that the assessment of whether a state owes a negative or positive duty to the applicant to secure Article 8 rights is broadly similar. This means that the court reviews the situation at hand by analyzing whether a fair balance has been struck between competing interests, with a certain margin of appreciation, of course, and in assessing the needs of the community as a whole vis-a-vis the individual applicant. These principles have come up again and again in environmental case law. Now let us see how the court has utilized evidence to pinpoint how the balancing scale has shifted in favor of one party over the other. A wealth of evidence was presented in locus austria. Expert opinions from university scientists, the National Toxicology Institute, the Regional Environment and Nature Agency, as well as medical certificates and even statements from police officers who were working in that region. Most remarkably here, these reports have all been rooted in domestic action. The domestic judge, for example, ordered assessments, and local and national institutes were involved to determine the severity of nuisance and potential impacts on private life aspects. In other words, the court did not have to rely on general standards set by an international body such as the HWO or UN bodies when concluding that pollution levels indeed had exceeded the norm. Such findings really seem to sway the court towards finding a violation. With regards to claims posed under Article 3, the court found that the conditions in this case had been difficult, but did not amount to Article 3 degrading treatment. And for me, I'm wondering exactly how does the court determine this threshold? In this instance, constant smells, fumes, and noise pollution leading to the daughter having severe health issues did not suffice. Here, I really wish to see to delve deeper into understanding how an instance is proven and how the court determines whether this instance reaches a certain threshold. Now, the second case, the infamous or famous Hatton against UK, I should say, which was decided in 2002 by the Grand Chamber, concerning the authorities' more permissive regime of night flights at Heathrow Airport, which regularly inhibited the applicant from falling asleep. Contrary to the Chamber judgment, the Grand Chamber found that a fair balance had indeed been struck between the competing interests. The case struck me because it particularly focused on adequacy of studies carried out by the authorities prior to implementing a system of noise quotas. Now, a very interesting aspect here was contradicting evidence. For instance, the government heavily relied on a so-called 1992 sleep study, which concluded that even at peak noise, it wouldn't cause any measurable increase in overall rates of sleep disturbance during normal sleep. The applicants, in contrast, relied on international reports, namely the HWO Guidelines for Community Noise, which recommended that noise should be below 60 decibel, a whole 30 decibel difference to the acceptable noise levels cited in the 1992 sleep study. In this case, the majority erred on the side of the government and accepted its review. The principle of subsidiarity here clearly influences the intensity of review applied to the provided evidence. Contradicting international reports or consensus may in this case even have to give way produced at the national level. Now, in its assessment, the court also stated that a sensitivity to noise includes a subjective element, thereby perhaps even inferring that the applicants themselves may be the outlier or anomaly, representing persons who cannot accept generally acceptable noise levels. It also comments on the fact that the applicants have not submitted any evidence to highlight the degree of discomfort suffered. I would be curious how the court would define a scale or the varying degrees of sleeplessness and its impact on human rights, particularly given that in light of numerous scientific evidence indicating the drastic effects of sleep deprivation on human health. The court then proceeds to address the request for a special approach. Here it quotes, it cites, it would not be appropriate for the court to adopt a special approach by reference to a special status of environmental human rights. This is done in light of the fact that the government submitted sufficient evidence as to the local authorities' assessment on the matter, and in such instance, domestic policies will not be necessarily interfered with. Here, the court also clearly rejects the idea that environmental human rights per se exist. Instead, it emphasizes that particularly protected convention rights, in this case, right to private and family life, must be directly affected for the applicant in order to be considered by the court. In essence, the court speaks of greening human rights as opposed to affording special protection to the environment. This statement is somewhat altered in the consequent case. I would still like to continue discussing Hatton because it's just such an interesting case though. The court clarifies the two-step review of domestic environmental policies. Firstly, it assesses the substantive merits of the government's decision. Secondly, it scrutinizes the decision-making process to ensure that due weight has been accorded to the interests of the individual. The court also highlights that it is required to consider all procedural aspects, including the type of policy or decision involved. Here, the court at times seems to overly perhaps rely on this procedural consideration to the disadvantage of other reviews. And a question thus begs to be asked, namely, is the international judge at times even rubber stamping domestic decisions if it was demonstrated that some level of engagement with the issue had occurred? Which may be a rather controversial question, but I'm still posing it and putting it out there. Next, I would like to discuss some of the dissents. Needless to say, very strong dissenting voices and interesting ones. Judges Costa and Thurman realized that the case transcends a mere dispute surrounding noise, as it represented an opportunity really for the court to acknowledge, and I quote, the close connection between human rights protection and the urgent need for decontamination of the environment, which leads us to perceive health as the most basic human need. This statement showcases the dissenters' awareness of international documents such as the Stockholm Declaration, the EU Charter of Fundamental Rights, and the Kyoto Protocol, as well as the HWO, where health is described as a precondition to meaningful privacy and intimacy. This reference to international documents already seems to establish a pattern. When judges are more in favor of environmental protection, such as in locus austria, or here the dissenters in Hatton, they make greater use of available international documents, all of which emphasize the importance of protecting the environment. The dissenters then go on to analyze the evidence presented. They emphatically state that the HWO guidelines, as presented by the applicants, represent objective criteria for measurable effects of noise on sleep. Therefore, the majority's insinuation that the applicants may be oversensitive or capricious, which was a quote, is an unfair presumption which should have been perhaps debunked by taking a closer look at the international guidelines on noise. The dissenters also go on to focus on the substance of some of the evidence presented. For example, the government's main reliance on the 1992 sleep study. According to the dissenters, the sleep study did not even address the applicant's precise issue, namely the inability to fall asleep in the first place, as opposed to being woken up from noise. So this is quite interesting to what degree they actually use the evidence at hand and scrutinize it. Now, lastly, the third case I wish to present is Tatar against Romania, the most recent ones of the ones I will be presenting today. It was decided in 2009. The applicants, which were residents of a small industrial town in Romania located next to a gold mine, were exposed to an accident at the gold mine, which caused pollution both within Romania and leaching into further countries. Here, a violation of Article 8 was found on account of the Romanian authorities' failure to protect the right of the applicants to enjoy a healthy and protected environment. The applicants in this case rely on the, quote, body of direct and indirect evidence, which corroborates the decline in the second applicant's health problem with asthma. Here, the causal link is to be established by reference to medical certificates and several of the international studies, such as HWO and British air quality studies. The evidence stands against the government, which refutes a causal link, as causal links were questioned by a 2001 study, which the government brought forth as evidence. Interestingly, in this case, unlike in Hatton, contradicting evidence is partly, at least, resolved in favor of the applicants. In doing so, the case certainly benefited from a really hybrid situation of domestic and international documents presented to the court. The chamber was able to scrutinize permits, environmental impact assessments, an HWO study, a US study even, a UK government-initiated air quality standards advisory group, and medical certificates. According to an interview I held with an academic and practitioner in the environmental litigation field, official documents here named namely documents enacted by the government, is taken rather seriously by the court. What made a difference with Tatar was also the fact that there were a certain number of governments confirming the toxicity of the substances in question. It also made a difference that at the domestic level, there existed a constitutional right to a healthy environment. Now, it'll be interesting to see how the court takes this into account in the cases. To quickly discuss some of the principles, the court in Tatar establishes an important principle, namely that Article 8 may find application in environmental cases, whether pollution is directly caused by the state or whether the state's liability arises from the lack of adequate regulation of the private sector activity. Now here, the latter sentence is incredibly useful also in the context of climate change litigation. If a state can be held responsible for its polluting industries, it would be a rather powerful tool to use. Something remarkable happened in this case. The court's principles even discussed the precautionary principle, and it reiterates that the state should not delay to adopt effective and proportionate measures to prevent the risk of serious and irreversible damage to the environment in the absence of scientific or technical certainty. This not only lessens the burden on the applicant to prove absolute scientific certainty, it also requires the state to act preemptively with a view to avoiding the most grave environmental damages. If the court takes on this principle in climate litigation, it may very well be capable of alleviating the burden of proof from the applicants and placing a higher burden on the state to act in a manner that resembles a precautionary approach. The court also considers a range of important issues, such as the issue of causal probability, being aware that it can never be absolutely certain that the pollution in question causes the illness of the applicant. It goes on to state that despite the absence of causal probability in the present case, the existence of a serious and substantial risk to the applicant's health and well-being place the state under a positive obligation to adopt reasonable and adequate measures. The applicant therefore must be able to enjoy more generally a healthy and protected environment. Now, these tones are very different to the prior case law discussed. The issue of causal probability is also taken up by the dissenters, however. The dissenters engaged in a fascinating critique concerning probabilistic thresholds and standards of proof. The majority expected the second applicant to prove a causal link between the exposure of the pollutant and the aggravation of his asthma, and indeed find against him in this case. The dissenters point out that the majority here switched from this probabilistic approach to a classical causal approach, where it is it's a higher standard, so it's much harder for the applicant to prove. They point out that in the present circumstances, opting for an all or nothing approach is completely inappropriate because, according to the dissenters, toxic damage is not necessarily an immediate phenomenon and oftentimes even invisible. Therefore, relying on the applicant to prove the causal damage might, in essence, be impossible. The dissenters also state that the legal process in which the search for truth is a just means to resolve conflict and not an end in itself tends to distort the perception of reality. Now, this sentence, which is quite loaded, I believe is crucial in understanding how judges approach evidence and what the limits of evidence and indeed litigation in general are. In the end, resolving a conflict may not bring about the truth, and the dissenters critique here that the majority kind of accepted this without trying to go further than that. In conclusion, their view is that private life cannot be limited by the absence of absolute certainty, most notably not so when it is in the context of diseases. The judges further ponder on the issue of correlation. For example, is a small percentage or a much higher percentage of diseases occurring after an environmental event or a disaster indicative of the cause of the disease? And how should judges indeed know? The judges crucially here grapple with the question of how can scientific evidence be utilized in a manner that members of the judiciary correctly decide according to their informed understanding of how certain scientific facts impact the applicant and consequently potentially impact the human rights. The dissenters also point out that there exists no precedent when it comes to novel risks such as public health or the environment, a statement that also obviously rings very true in the current pandemic. Therefore, relying on any sort of statistical frequency for disease occurrences may indeed be redundant. A key point to take away from the dissent is that they opt for a different approach to causality. They think that the presence of a favorable circumstance, in this case, environmental disaster caused by the factory, combined with an absence of a discernible cause, for example, another reason for asthmatic disease, makes causation sufficiently probable in the eyes of the court. Anything else is seen as an impossible burden on the applicants. Therefore, the absence of harm should have been the determining factor through which the government could have defended itself, but in this case, it didn't. To sum up, the cases I've presented to you, as well as other cases I've obviously read when studying the ECtHR, have provided me with much food for thought. As I said, it's very preliminary and I'm still in the questioning phase. Some of the issues I've been made aware of are Potentially procedural requirements such as producing a study or risk assessment may trump qualitative substantive assessments. It seems that the Strasbourg court seems to favor domestic reports, such as those commissioned by the government or even the industry itself. It's also interesting to see whether the court continues to develop a special approach with regards to environmental human rights. At the moment, there are very mixed messages coming from the court, with Tatar being an exception. The burden of proof also at times seems impossibly high on the applicant. And with several dissenting voices pointing this out, I'm really eager to see how future judgments may grapple with this issue. Now, the issue of direct and indirect evidence is also of interest. While sometimes we do have foolproof evidence directly pointing to causal links, the court also had to rely on inferences to establish causation. And my question is, how does the court use inferences in this regard, and when is it willing to draw inferences? Lastly, I wish to also dig a little deeper in understanding which pieces of evidence seem particularly weighty. For example, a question of medical certificates are clearly expert evidence. There were several cases, however, where the court appeared skeptical as they were commissioned by the applicant themselves. So my question is, when are medical certificates indeed useful, and what other evidence could even prove to be more useful? And going back to the original contextualizing, namely the pending cases before the court at the moment, I wish to draw, very hesitantly, but I wish to draw some kind of conclusions and forecasts. So by asking the question of how could a perfect case look like when it comes to the European Court of Human Rights? And according to what I've read, it seems that it would definitely need prior findings of interferences of rights by domestic courts. It might also benefit from interventions by other international courts, such as the ECJ, which has intervened in some of the cases I've been reading. Evidence of a number of domestic reports pointing to compromising circumstances would help, and the burden of proof would ideally be shifted on the government. International reports should include a variety of sources, namely also more recent things that have come up, such as scientific evidence focusing on special vulnerabilities, such as youth issues and elderly women's issues in the present case, as well as state-of-the-art climate science, such as attribution science. And lastly, it's also interesting to see whether a domestic right to a healthy environment will have an impact on the court's decision. So this is my little thing. I think I've stayed within the time frame, and I'm happy to hear feedback, questions, and concerns. So yeah, thank you.